People of the State of Michigan versus Hailey Crager, 2123725. Ms. Crager is here on a charge of unlawfully driving away an automobile, a felony punishable by up to 5 years in prison. Plea agreement involved no objection to bond and would be agreeable to, I didn't write down what that was, but I guess a no objection would be agreeable to a bond is what the prosecutor said. So Ms. Crager is here with her attorney, Mr. Gibson. The prosecutor is Mr. Gabriel, and we're here today for sentencing on this case. Mr. Gibson, does Ms. Crager have any objection to continuing on video today?
No, Your Honor.
All right, Ms. Crager is here, as I said, and do you have any additions, corrections, or deletions? Mr. Gibson?
The only item is on CFJ 284, page 7, which has, toward the bottom, it says marriage, and it lists Olivia and Anthony Kipfer, and it's got a short paragraph under that. The name is actually spelled K-I-P, F as in Frank, E-R. So it's an F instead of an L for the last name Kipfer.
Okay. Kipfer.
Other than that, I have no other additions, corrections, or deletions.
Okay. All right, Mr. Gabriel?
Nothing, Your Honor.
All right, the agent recommends the prior record variable be scored at 35 points, level D, and offense variable 10 points, level 2.
I agree with that scoring, Your Honor.
Your Honor, I would object to the scoring of offense variable 19, and I could be wrong, but I believe that when this occurred, the report indicated that the officer felt that the defendant may have been suffering from some sort of a psychological situation, and she indicated that she had been detoxing and having some hallucinations. He gave the name, it said Sarah Craig, which I don't know if, I guess I would question whether she intentionally gave a false name, because Sarah is her middle name and her last name's Crager, and so I guess I would just object to that scoring, but I guess it could be scored possibly, but I guess the question comes down to is, does it require that she intentionally did something, or did she accidentally, I guess you could say, affect the administration of justice?
Okay. Well, she gave the name, and she didn't just pull it out of the air. And if you're trying to argue that she was under the influence and therefore isn't responsible, as you know, and as Ms. Crager should know, the voluntary consumption of a controlled substance that affects your ability to think clearly is not a defense. So I do find it's properly scored, as she did give it a wrong name, and therefore it did interfere with the administration of justice as the officer tried to search for that name. So I'm scoring 10 points. With that, the guideline range calls for a minimum sentence of somewhere from 7 months to 23 months. This is what's known as a straddle cell. It could be a local sentence or it could be a prison sentence. And so with that, we should reflect that before coming on the record, I spent some time talking with Ms. Crager about her criminal history and her failed probations in Indiana, and that whether or not she'd be interested in the Swift and Sure probations program, which would provide her more resources to deal with her issues, and she felt that she has things under control and is ready to proceed with just a normal probation. And so we did have that discussion. So in addition to that, Mr. Gibson, what should I know?
Your Honor, the defendant has made strides over the past several months. She was in jail and she was forced to abstain and to detox. In speaking with her at the jail, she indicated to me that she was suffering from the effects of detoxing for about a week at the jail, and she had a very serious addiction to methamphetamine, and that obviously is very concerning when you're having withdrawal symptoms. And I think she recognizes how dangerous and how scary that can be, and that she does not want to be that person anymore. And I believe that the defendant, over the last several months, she's got a very good attitude, and I think she's motivated to hopefully do everything she's supposed to on probation. So I would ask that the court follow the recommendation from the Department of Corrections. Thank you.
Thank you, Ms. Crager. What else would you like me to know?
Just nothing else.
Okay, Mr. Gabriel?
Thank you, Your Honor. Your Honor, a couple of factors here that really concern me. Obviously, the degree, yeah, and I haven't been through a lot of the training I know the court has regarding drug court and methamphetamine. But when somebody says she has a very serious methamphetamine addiction, but gee, I'm really doing good now and I'm going to be okay, I have some real concerns about that. I'm going to suggest something, and I could be totally out of line, and the court will certainly do that. I know that with the revisions the legislature's proposed regarding probation sanctions and things of that nature, we have a situation here where the guidelines, the minimum, the bottom end of the guidelines requires, if the court were to follow them, requires 7 months in jail. If the court follows this recommendation and there's no jail time right now, and she's put on regular probation, we go through this graduated escalation of sanctions, which don't even reach until I don't know how many violations, that we get back to a point where the guidelines matter. I'm going to suggest, and it would be illegal maybe, I don't know, it'll be up to the court, that the court impose a probation sentence with 7 months in jail. But that the court suspend that 7 months at this point in time to allow Ms. Crager to show the court that she means what she says and that she'll be able to abide by the terms of her probation and not use drugs, et cetera, knowing full well that if she does violate the terms of that probation, the court will impose a 7-month sentence.
It's funny you brought that up because we had our judicial conference last week, and that was one of the suggestions a judge made as to what could be done. And it was recognized that suspended sentences, which they do a lot in Indiana, are completely meaningless. Because in order to impose any additional jail time, you still have to have another hearing, and you have to do it, and you would still have to follow the statute as far as that goes. So it wouldn't do any good to do a suspended sentence. So what I want Ms. Crager to know is that, you know, several things, and you're exactly right, Mr. Gabriel, that, well, let's go back. I mean, the agent's description of the offense, February 13th of this year, so just 3 months ago, they were dispatched to the Sunny Mart in Sturgis, where a vehicle was missing. The owner of the vehicle described the car and its distinguishing features. The officers arrived, asked him what happened. He had stopped, gone into the Sunny Mart, purchased a pop, comes out, and his car is gone. He left his car running outside in the parking lot. Asked if he had observed anybody lingering around. No. Asked Jonathan if the vehicle were recovered, would he want to process it? He said he just wanted his car back. As they're standing there at the Sunny Mart, the officer looks across the street and sees a Chevy Impala traveling westbound, pull into the Admiral station across the street, and then take off. And he immediately noticed that it had the same distinguishing marks So you drove right back to the scene across the street, and the police took off after you. Conducted a traffic stop on the vehicle, came back a short stop later. The officers drew their firearms, pointed it towards the vehicle, gave the driver loud verbal commands. The driver then slightly rolled down the window and placed her hands outside, informed her to step out of the vehicle, walk backwards. She was handcuffed. She appeared to be under the influence of something. She was bending down, hiding her face, continuing to move her fingers and wrists. Escorted you to the patrol vehicle. You said your name was Sarah Craig. You appeared to have some sort of psychological issues. Asked if you needed medical attention. You said you did. You tried to say that you were possibly going through detox withdrawals and you were hallucinating. They took you to the hospital, checked you out. They found a backpack in the back seat, and the owner of the vehicle said it wasn't his, appeared to be yours. Told the ER physician the only drug you'd taken that day was marijuana. You were detoxing from other drugs and alcohol. They cleared you to go to police custody, and you were clearly under the influence. You were shaking and everything else. She indicated she was hallucinating and anxious. She advised she was having dangerous thoughts and that she had not received any treatment in 2 years. She advised that she understood the importance. Looking at your criminal history, you have a theft out of Steuben County in 2017 where you got a year jail, suspended. This is where that whole suspended thing means nothing, Mr. Gabriel. 12 months probation, and you ended up getting revoked and doing 102 days jail, even though you were originally sentenced to a year. And then in Steuben County in 2018, you had possession of methamphetamine. They dropped it all the way down to possession of marijuana, gave you 180 days in jail, all suspended, 12 months probation, and you had that probation revoked and ended up doing 90 days in jail. Then on April 24th, 2019, possession of methamphetamine and false report of a misdemeanor, they gave you 12 months jail, credit for 40 days served, and 60 days jail. And then in 2021, you have this offense where you stole the vehicle while under the influence or going through withdrawals. And you indicate to the agent that you understand your drug addiction is the overriding factor for your criminal behavior. But you advise that you would comply with probation, however, you don't feel that you need it. You feel that you can effectively manage your addiction and does not feel probation is necessary. Although her determination is admirable, it is this writer's belief that more intensive treatment is needed. There are several obstacles she needs to overcome, and her support and resources are limited. She would benefit considerably from the structure and guidance community supervision could provide her. The goals of the probation are rehabilitation, to address criminal opportunity, your leisure time, your use of leisure time, social isolation, substance use, criminal personality, criminal thinking, cognitive behavior, residential instability. You'll need to complete substance abuse treatment as well as a complete mental health assessment and treatment if recommended, as well as some form of cognitive behavioral therapy. You'll also need to maintain a stable residence and employment along with increasing your pro-social peers and activities. So I'm going to place you on probation for a period of 1 year at this point, but you must complete the following. You are to do a substance use assessment, you are to complete mental health treatment, you are to do MRT Thinking Matters, you are to obey all court orders, you have to have a license, you may not engage in assaultive, abusive, threatening, or intimidating behavior, you may not change your residence unless you obtain written permission from your agent beforehand, you may not have any weapons, you must contact your agent no later than the first business day following your placement on probation, you must comply with the written or verbal orders made of your agent, you must allow the field agent into your residence at any time, you must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You have to maintain employment and you shall not be fired or quit employment without your agent's permission. You have to serve 54 days jail, credit for 54 days served. There's a $60 DNA fee, a $68 state cost, $130 crime victims assessment. Your supervision fee is $30 a month. If you're placed on tether, it will be $60 a month. Your court costs are $527. There's a fine of $100. And again, you have to be subject to a search at the request of your agent or any law enforcement officer in terms of this. So we'll try this and see how it goes. And just be aware that if you do violate, that you could face up to 23 months on the minimum, up to the 5 years on the maximum, but we don't think that'll happen. You've got a strong start, you need to continue on it. But realize, that there won't be any, every time there's a violation, the agent will let me know. So every time you don't attend a treatment, every time that you don't attend a testing session, every time that you don't appear for your agent will be a violation, and you'll have to appear in front of me and explain what's going on, okay?
Okay.
So there will be accountability. The agents understand that there's no room. It's a more intense supervision these days because not a lot of people get put on probation, and that's it. And just realize that you're facing a potential prison sentence here if you don't follow through. So let's hope you do, okay?
Okay.
All right, so you've been given 3 forms advising you of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you need to fill the rest out, return to court within 42 days. Also, Ms. Crager, I have to advise you that if you were able to complete all the terms of your probation and remain violation-free, you could seek early discharge from your probation, but it's going to require a lot of work. Also, your probation can be extended for up to 3 years if needed, and so make sure you work hard with your agent. We're going to go off the air, and I'm going to give you the name of the agent that you need to talk to. You need